Hi guys, it's Kathy. I hope you're doing well. Lori's coming home today. She's coming home to my home, but you guys don't know that. Lori, I can't wait till you're home. Start this stream over. Nope. No, I'm a professional. I am a professional. I roll with it. I roll with it. It's oh come on, I've done way worse. I've done way worse than all of this madness. It's okay. Look, it's time for court vibes. So, of course you do. Of course, because I was muted. Man. Okay, that was nice. So, I got one clip from La Casa today. Hopefully it's good because I haven't seen it. I've got a hostile witness that I may or may not have the whole sorry. I definitely don't have the whole trial, but I may or may not have the good parts in the verdict. Um, I hope the verdict is today, and I'm going to try to get it today, and I'm super excited. If not, we're just going to leave it with this one clip that we get to see today. We're happy for it because one clip is better than no clip. But the judge sends the jury out and admonishes her, and from what I gather, wasn't the first time he's done that to her. So that's great. Then we got a real creepy guy from I want to say from Jersey because that's where he is now. And the only reason why he's there now is because she moved states away to get rid of him, and he just followed her. And then oh yeah, then we got a custody hearing, and all I got was the dad. And I'm gonna get comments about that. I don't care. You'll see. You'll see why all I got was the dad and the verdict, of course. So, which one do I do first? I'm gonna go with the one where all I got is the dad. So that's where I'm gonna go first, and no one can stop me because I have the mouse. You guys, I don't know. I don't know what's going on today. Really, listen, I'm really good with computers. I just really am. I mean, they respond to my touch very nicely, but not today. Today, not today. Okay. I'm pretty sure I'm clicking the right button. I didn't. Okay, I did, but it was a while ago. I mean, I was working, so it was a while ago. Listen, let me tell you how much I love you guys. Let me just tell you how much I love you guys since we're talking. This guy comes into the bar tonight. He has a code shirt on, code. I don't know what these hats are. I'm not really good with names of hats, but I'm sure you guys know. Um, it's those hats that are like flat and they like snap in the front. The guys wear. They're like flat. They like point. And they like snap in the front. Donald, help me out here. I'm dying. What is that called? Anyway, he made perfectly inappropriate comments at the right time to not be in this latest bit creepy, but very funny. Um, we had trivia tonight, and he was winning when I left, winning trivia. So that means he was pretty smart. I was speaking to him for a while. He was pretty smart. And I got cut early. And he's like, "Hey, come on over and have a drink with me, and we'll do trivia together." He was winning. He's very smart. And of course, we had a conversation. And I asked him, I said, "What do you think about peanut butter, mayonnaise, and pineapple sandwich?" And you know what? He's like, "I would be fine with peanut butter and pineapple." That's what he said to me. And instead of sitting and having a drink with him and winning trivia, I knew that I had to get the trial with chrysanthemum. So I left. I left and I got chrysanthemum today because I love you guys and I know that you guys want to see it. And you can't rewind that. You got to get it while it's hot because once that stream is over, it's over forever. So I'm sure he got first. I mean, he was significantly ahead of the pack when I left. But that's how much I just love you guys. So now I'm going to click a button, please. Please.
And would you be
Yay,
comfortable
look at me
splitting costs of
go.
JAL with Jordan?
Absolutely.
Thank you, Your Honor. No further questions.
Thank you, Cross.
You had testified you're not allowed to have parenting time. How many times have you in this last since Mother filed her emergency motion? How many times have you asked to have parenting time?
Just recently, because under my assumption, once emergency custody paperwork is filed, I'm not allowed to see them. And then, when I try to speak to her, it's pretty mean. It's almost like
Okay, so just how many times have you asked?
Twice.
That's hot, Kelly.
Let's see here. So you testified that you were arrested because of some miscommunication about a treatment program. But if I look at the notice of the violation of your probation, it says you failed a drug screen that had a positive result for amphetamine. It says returned a positive result for amphetamine that would indicate use of an illegal drug. So tell me about that.
I mean, to my knowledge, I was prescribed it at one point, and then I took it a long time ago. And
how long is a long time ago?
It was like around April.
A long time ago, back in April, I was on drugs legally.
You were prescribed an amphetamine?
Yeah, prior, yes.
Okay.
Not anymore, it's not something I should have did,
Okay, and you still have an evidentiary hearing for that case coming up September 9th, don't you?
Yes.
Okay, so you're still on probation for that case. That's not over yet.
No, we're waiting to discuss to get it dissolved through the counseling program. The main issue was the counseling program. They want to make you go through these certain programs to see your commitment to, what you did. And this is something I've been trying to move on from, and I put a lot of hard work into myself.
Okay.
People have to get over their past.
Okay.
April.
So that case is still not resolved.
April.
That case is still open, right?
It will be
That's the answer.
resolved quite soon.
I have to get over my past, which was a long time ago in April, but it's still open. But it's still my past. And you guys, why do you keep bringing up my past? I don't understand. Hope, thank you so much. Treasure X was gifted a membership. Treasure X, I miss you.
Let's see here. Judge, I'm sensitive of your time, so I think just in the interest of moving on, we'll just end it there. No other questions. We'll save everything else for a later hearing.
Well, thank you. Any redirect?
No, thank you, Your Honor. Sorry, Your Honor, can you?
Okay. The violation of probation was filed on July 18th. How many drug screens you've taken since then?
I believe 3 or 4.
And that's the only violation that's been filed?
Yes. And then I'd get one once a week. So from here on out, at least for the next 9 weeks, and then once a month from her. So 5 a month I would have to present.
Once a week on Tuesdays through Fairbanks, and then once a month you get tested from probation.
So 5 total times a month, I'd be able to provide documentation that I'm not abusing substance.
I would hire that lawyer in a heartbeat. So while she's thinking, I can tell you the backstory of what I know. There's mom. Mom wants him to not have custody anymore, so she had this emergency hearing. But because of drugs. But the judge just heard that he tests once a week for something, and then once a month for her.
Court finds that there's insufficient evidence to modify parenting time on a preliminary basis, and the court denies the emergency motion for modification. The court does order
She mad?
sign a release for both Fairbanks and his probation officer, so that reports from probation can be released to the court. Reports from those two entities can be released to the court. What I'm going to do is refer this matter to our service referral center and just put on there that, and our coordinator's name is Aileen Wood, so that Ms. Wood can coordinate with probation to get the screens, and then she can supply that to the court in a report, and I can turn that over to counsel. So
that's what it is. Once a week for his probation officer, once a month for her.
what's the name of your probation officer?
Amanda Fangman.
You know how to spell her last name?
Fangman.
And this is Hamilton County Probation.
Yes.
Obviously, if the court gets notice of any positive screens, the court will be hauling everybody back in.
Oh, you're hauling people in.
Same parenting time schedule. The party shall follow the order from 2023. The court will defer the issues of modification of legal custody and the rule to show cause on financial matters. The court does not think a Garnett Litem is needed. I would be willing to put them on the wait list for Kids Voice Parenting Coordination program. I think that's probably a more appropriate platform that might help these parents co-parent.
Not enough.
So if you want to talk to your clients about that and then notify the court as to whether or not there's an agreement to that effect, I will hold that for 2 weeks till I hear back from both.
I know he has makeup on.
Help
Yep.
this family more than a Garnett Litem would.
See?
I'm also going to order the parties to participate in the mediation days to mediate the final issues.
It looks great.
On November 22nd at 9 a.m. And I'll do a separate order to that effect. And then I will give you a new date.
Judge, I'm sorry, can you repeat the last thing you said about mediation? I was trying to keep up with my notes.
I'm going to order that. Since there's a modification of custody, they'd be ordered to mediate.
But he can,
a
and it would
modification of
look
legal custody
great.
would be ordered to mediation, so I'm ordering them to mediation
Definitely.
days on November 22nd, and I'll do a separate order to that effect.
Okay.
Your Honor.
She mad. She mad, bro. She mad. She started shaking her head, but it was boring, so I stopped it. So, yeah, she did not win that, even with her fabulous lawyer. Okay, let's go to this hostile woman. We're going to go to a hostile woman in Harris County, Texas.
As you would with your own counsel asking questions, right? So I'm doing this to help shorten time. Please just listen to the question and ask that question. Please try not to be as defensive.
Sorry, they're all standing up because he just kicked the jury out to admonish her. He's like, just answer the questions.
Vague questions being answered. I will tell you my experience that that's not very helpful to anybody and it just drags on the trial. If he instructs me to, from now on, if he asks me to instruct you to answer a question, I will do so. I'm giving you one admonishment first. Do you understand?
Yes, but may I ask a question to that?
Yeah.
It's how he's asking the question.
I get
So
that.
I can't answer what he's asking me the way he's asking me.
Okay. I haven't seen a problem with the way he's asked questions yet. I think it's not the question you necessarily want to answer.
Thank you.
Don't give me a face. Don't look at me. Don't give me a face. Don't do that. Don't do that to me or anybody else.
Taser.
You're in the courtroom. The more faces you give about certain things that you don't like, I'll tell you the jury's going to pick up on it. I pick up on it. They pick up on it. I've already admonished you about that a day or so ago about making faces and things about questions being answered or testimony that's been getting given. So I already done that. So don't do that, and don't do that to me. I think the questions he's asked have been on point and could be answered directly. So I'm going to admonish you real quickly again that if he asks me to instruct you to answer the question directly, I will do so. And I don't want to do
Maybe
that
that's a sign.
because that carries a certain weight with the jury about credibility of the witnesses, right? So please don't let me put me in that position and us in that position. If you don't understand a question, say, sir, can you ask that question again? Perfectly fine. We only want you to be obviously answering truthfully and in your personal knowledge. So we want to make sure you answer the question, but please don't, you're not there yet being hostile. But you're asking to treat her as a hostile witness, which means that that it can be facilitated by leading questions to help move us along. Okay?
And Steve,
I think so, yeah.
Do you understand?
Yes. Yes.
Don't give me a face.
And that
Do
was a
you
lie.
understand?
Sir, I'm not giving you bases. I'm really just answering your question. This is a very nervous situation. And I feel like every time I make any facial expression whatsoever, you tell me I'm giving you a face, but I'm not.
Well,
So I don't know what to do facial wise.
it's best not to have you respond facially to lots of things.
Okay.
You do. I don't know if you know. It sounds like you don't know this, but you do.
Okay.
So try not to do that.
Okay.
doesn't he look like a priest with that purple going down the front?
Got it?
Okay. Yes.
Yes.
Yes. Check.
Okay. Let's bring it back in.
Wait a second. I just want to approach the witness. This is just a refreshing recollection associated with personal property damages.
You can do that on your turn,
Probably not. She's a Karen.
or you can ask for the jury. But let's not do that right
Can
now.
I give this to bailiff so I don't have to walk over there because I'm stumbling around?
Let's do that in front of the jury.
All right. Thank you.
Okay.
Wait till I do it or do it now.
Do it when it's appropriate.
All right.
Okay, so I didn't stop it there. I thought that I would I would thought I would play a little bit more so you guys hear him questioning her and her answering a bit, just a little, just a tip. Stop making.
Okay,
faces
be
at the
seated.
jury.
Continue.
Your Honor, when I
Okay,
speak,
ma'am,
you
for
don't.
clarity again, I want to ask, do you ever tell anyone that you may consider choosing lower grade or builder's grade type items in order to get additional things done in your house outside of the scope of work?
Yes,
Okay, and who did you tell that? Did
Angel.
you ever tell anyone else that?
Yes,
Who else did you tell that?
my insurance adjuster.
Now, this is not your testimony, and this is your chance to set that straight, because there's been basically running commentary by your attorney that you never asked for this lower grade. Was that an incorrect statement by him? You're telling the truth now?
I'm not a witness.
That's correct. So let's keep it to the witness testimony.
Can you repeat the question?
So it is true that at some point you did say, hey, I'm going to consider some other items so I can get more work done, correct?
Yes,
You told your insurance agent that?
Asked and answered.
Yes.
yes,
You told Brooks Construction that through Angel, correct?
Asked and answered.
yes,
And then you expanded the scope of work outside of the original scope to get some additional things done by Brooks. I'm not saying necessarily the insurance is going to pay for it, but you did expand that to add on the bedroom, correct?
no,
So you never added on the bedrooms. I'm going to
Yes.
ask you to look at what's been pre-marked as Exhibit 6. And this is an email from you to Desiree Marino.
Mhm.
Okay. I'm going to go down here, and I want you to look at paragraph 3, right there on those last two sentences. Can you read that out loud to me?
I mentioned we may choose lower grade flooring, cabinets, etc., to help with our separate add-on items. Guest bath. Keep-
Okay. And the add-on items, can you complete the rest of the sentence?
Add-on items, guest bath, costs that we were asking Brooks to complete on this side, further improving our house, and you confirmed that was okay.
I'm
So
sorry.
you had the conversation with the adjuster about this very issue and also with Brooks.
Yes,
And at this point, what is the date of this email?
July 7th.
Okay. And had the work started yet?
No,
Why had the work not started?
I don't know.
Do you recall there being a delay from the insurance company getting the initial bid approved?
No,
You don't recall anything of that nature at all? At this point, were you still happy with Brooks Construction?
yes,
Because you had statements that you were unhappy from the very beginning. There were problems all the way through. Did this whole process start in June or May?
it started in July.
So there was no interaction in June. There were no delays. There was nothing going on in June. Nothing started in July.
No, that's not true.
Uh,
No, that is not true.
So please tell me the truth.
What do you
had
ask?
started?
Can-
Had the
what do
work
you ask?
started or had not started in June?
The work had not started in June.
Had the bid been presented to your insurance company in June?
I don't have the exact date in front of me.
But as of July 7th, you're still happy with Brooks Construction, correct?
Yes,
Can you read that? Well, actually, it says they're professional, courteous, very responsive. Was that an accurate feeling of excellence?
yes,
So as of July 7, you're still happy.
I have a feeling she's never happy.
Seven. And we're 7. Second page. So again, this is a message from July 7th. Can you read that response to me there in green?
This is the 6th, sir. It says, thank you so much for your help. You guys are great. And with the response average that we get from her, I appreciate Brooks always having timely responses.
Could we have the screen lower, John? Oh, sorry. Okay. Had you ever told anyone, and we're going to Exhibit 8 now, that you may consider something other than porcelain to replace your tile?
I don't recall.
Okay. Is it possible you did?
I don't recall.
Okay, I'm going to show you what's been pre-marked as Exhibit 8.
Go get her, Donald.
And I'd like you to look at the date on that. What's the date on that exhibit?
June 15th.
June 15th?
Yes, June 15th.
Okay, so in mid-June, we were already involved in this process, correct? Work may not have started, but the whole process was going on.
So had been.
You would have
Yes.
to move to Texas.
Would you have sent an email to Trey Brooks that y'all weren't actually involved?
I would not.
Okay, so in June 15th, there was something already going on and Brooks was already working, correct?
Yes.
Okay. I'd like you to look at that second sentence in the first paragraph. Can you please read that to me?
We have porcelain tile now, but may replace with something else if you have recommendations.
Okay. So is it fair to say that you did tell Brooks Construction you would consider things other than porcelain tile?
Asked
It
and
looks like
answered.
it, yes, sir.
Okay, so anything that we've heard on testimony or side commentary that you never said that you would consider that, that was not accurate, and you're being truthful right now about what actually happened. You did say that.
Objection,
That's an answer.
doesn't reflect evidence. It's been admitted.
Overruled.
This one lawyer is trying to get everything the other lawyer said in as testimony.
Can you repeat the question?
So you did indeed tell Brooks Construction that you would consider things other than porcelain tile.
Asked and answered.
Yes.
No wonder she's hostile.
And at this point, are you still happy? Well, this was the start of the process, correct?
Yes.
And you're happy at the start of the process. You'd have a exchange going back and forth.
Yes.
Your bids are being looked at.
So
Trey
does
Brooks
this
is working.
one. Comfy.
Yes.
Oh, the one with the beer cans, or is there new ones? So I may or may not get, okay, not the whole trial, because this trial's been going on for days and all I got was like yesterday, which is enough, It's so when I went to work tonight and I was recording it and then there was a glitch, but it was only a glitch in the last bit. So they either the jury either came up with a verdict in that little glitch time, or they're going to give me the verdict tomorrow. If they're going to give me the verdict tomorrow, I will show more of this trial. If they don't give me the verdict tomorrow, this is it. This is all you get of this trial, which is enough because the judge just told her not to make a face. Now we're going to go to a stalker from, not from Jersey, but in Jersey.
Will address the State versus Carl Glass under complaint warrant 2024-292-1518. The defendant has been charged with disorderly persons contempt, violating a domestic violence restraining order, and also petty disorderly persons harassment. May I have the appearance of counsel, please?
Good morning, Your Honor. Assistant Prosecutor Emily Grimaldi appearing on behalf of the state.
Good morning, Your Honor. Bill Smith appearing on behalf of Carl Glass.
Thank you very much. And I just want to verify there's no motion to revoke release that's been filed. Is that correct?
That is correct, Your Honor. The defendant is detained on the underlying matter, and his other pending matter was issued on a summons.
Okay, thank you very much. All right, Mr. Glass, if you'll please state your full name and spell your last name for the record.
Glass, Glass.
Thank you very much, sir.
You're welcome.
Did you receive a copy of the charges that I just mentioned, or did your attorney read those charges to you?
I received a copy, ma'am, at the down here in booking at Ocean County Jail. I guess that's where I'm incarcerated at.
In booking.
Okay,
I'm
thank
not
you very
really
much.
Place, I'm sorry.
Okay. All right, when you were brought into custody, well, actually, when you originally had these new charges, when you received a copy, did you see a video which explained certain rights and programs?
Yes, ma'am. I remember the video from the first time as well.
Okay.
I remember that video.
And did you hear and did you
from the first
understand the
time
rights
I-
regarding detention hearings that this court read earlier today?
Yes, ma'am.
At this time, I'll address the defendant's eligibility for pretrial detention. We'll allow the state to enter the certification in support of pretrial detention evidence as
Salinas.
S1. Any objection by defense counsel?
No, Your Honor, thank you.
Right. S1 is admitted into evidence. This court has reviewed E-courts and S1, finds the motion for pretrial detention has been properly filed in this matter, and further finds that eligibility for pretrial detention has been established based upon the reasons set forth in S1. What grounds does the state rely upon for the defendant's pretrial detention?
Fozzie, can I show the clip? Can I play the clip here? Not right now, when this is over.
Your Honor, the state would rely upon the grounds as set forth in S1.
Court will now proceed to probable cause. What does the state rely upon to establish probable cause?
The state will rely upon S3, the complaint in this matter, S4A, the temporary restraining order, and S4B, the order granting detention on complaint warrant 2024-276-1518.
All right, thank you. That was S3 and S4A and B, correct?
Correct, Your Honor.
Thank you. Any objection by defense counsel?
No, Your Honor, thank you.
They're admitted into evidence solely for purposes of this proceeding. And what is defendant's position regarding probable cause?
Thank you, Judge. I would stipulate probable cause for purposes of today's hearing.
Right, this court has reviewed exhibits S3 and S4A and B. Finds for purposes of this hearing only, the probable cause has been established. However, there is a rebuttable presumption
How are
against
you?
detention. I will first hear from the state regarding its arguments in
Thank
support
you.
of pretrial detention. I will then hear from defense counsel regarding defendant's arguments in favor of release. Any additional exhibits the state will be relying upon in support of its motion to detain?
The state would also be relying upon S2, the PSA, and S5, the CCH.
Any objection to S2 or S5 by defense?
No, Your Honor, thank you.
They're admitted into evidence solely for purposes of this proceeding. The state may proceed with its argument when it's ready.
Thank you, Your Honor. Beginning with S2, the PSA, this defendant scores a 3 on the failure to appear scale and a 5 on the new criminal activity scale. The new violent criminal activity red flag is not raised. This defendant is before Your Honor with 2 current charges, the DP contempt, that is domestic violence in nature, and a PDP harassment that is also DV in nature. This defendant has 4 pending charges at the time of this offense on case.
Okay, I know. He's a bad guy. He has 4 charges. They're all against her. I just found out that I can like, heart, and reply to a super chat. Hey, I never knew that.
Number 242967. He has a 3rd degree stalking and a 3rd degree contempt charge with the same victim. And on 24-2965, there's a 4th degree stalking and a 3rd degree terroristic threat, again with the same victim. This defendant has 9 prior disorderly persons convictions and 6 prior indictable convictions, all of which are out of state. This defendant has 9 periods of incarceration, 14 days or more. Although the PSA does not list this defendant on probation, our office has been in contact with defendant's probation officer in Tennessee, who advised that he is in fact on felony probation.
Adam, this poor guy rolled a nat 1. If you play Dungeons and Dragons, he rolled a nat 1.
There is an active TRO in this matter against the victim who was subject to this offense. The victim has informed her office that she was going for the final restraining order on September 12th, but we did not receive any updated information. And most notably to the state is the fact that this defendant is currently detained in the Ocean County Jail on the actually the 3rd degree stalking and the 3rd degree contempt, I believe. As to the facts and circumstances of the instant offense, if Your Honor would recall, this defendant was detained by this court on September 9th, 2024, following a detention hearing. At the time of that hearing, the defendant was charged with stalking and contempt and had the pending charges for the stalking and terroristic threats, all against the same victim, VF.
Oh, I'm so
At that
angry at this
hearing,
guy.
and in the order entered as a result, Your Honor ordered the following: the defendant shall have no in-person, mail, electronic, telephonic, or other contact with the victim, VF, of the offense while detained. It is alleged on September 10th, 2024, the very next day after that detention hearing, at 11:21 a.m., VF
Nat 1, natural 1. It means you rolled a natural 1. So lots of times when you roll in Dungeons and Dragons, you get points plus or minus to what your roll is. So if you roll a 3 and you already have a -2, then you'll get a 1. A natural 1 means that you rolled a 1. That's the worst. It's horrible.
Received a missed call from phone number 732-908-1544. At 11:33 a.m., VF received another call from the same number, which she did answer. An answering machine advised her it was a collect call from the Ocean County Jail and this defendant was requesting to speak with her. VF hung up the phone. At 11:40 a.m., VF received another phone call from the same number and declined the call. The state has spoken with the victim in this matter, and she advised she would like the defendant to remain detained. VF stated this is the second time he has violated the TRO, which shows he does not care and will not abide by the TRO conditions. The state thoroughly understands, respects, and agrees with the victim's position. There are clear concerns for continuation of behavior and for the safety of the community, especially the safety of the victim. This defendant has 3 open cases, all involving domestic violence offenses against the same victim. Your Honor handled the previous detention hearing. I'm sure Your Honor recalls the facts of that hearing, but the state would be remiss if it didn't mention that this defendant followed the victim from Tennessee to New Jersey. He then followed her around Ocean County, including to Providence House and to the Manchester Police Station. Even in the restrictive environment of the Ocean County Jail, this defendant has still managed to violate the TRO, violate this court's detention order, and contact this victim on 3 separate occasions the very day after he was detained.
The very day after he was detained, he's contacting her. Linus, I have not watched that video yet that I just posted on Baldur's Gate, but I hear it's worth watching. But I don't know if there's swearing. I don't know. I didn't watch it. So proceed at your own risk.
The state is firmly convinced this defendant would not abide by any conditions of release if he were to be released. This defendant's continued pattern of behavior towards this victim and his complete disregard of 2 separate court orders is very concerning to the state. There is a serious risk he would pose a risk to the victim and would obstruct the criminal justice process if released. For all these reasons, Your Honor, the state is asking Your Honor detain the defendant pending trial, and unless Your Honor has any further specific questions, the state would submit. Thank you.
Thank you very much. Attorney Smith, the state has raised its concerns. I'll now hear from defense counsel regarding defendant's arguments in favor of release.
Thank you, Judge. As the prosecutor indicated, Mr. Glass did appear before Your Honor last Monday on September 9th on pending 3rd and 4th degree charges. He was ordered detained on those charges. So Mr. Glass and I did speak last week, and he is aware of the fact that regardless of the court's ruling on this new complaint, that he will remain detained on the Ocean County Jail. However, Judge, this new complaint we'd ask the court to consider is a disorderly person's offense as well as a petty disorderly person's offense in nature. If he is to be released, Judge, Mr. Glass does reside in New Gretna. He maintains his own residence there. And with regard to the public safety assessment, while he did score a 3 on the failure to appear scale, the report does note, Judge, that it doesn't appear that Mr. Glass has ever missed a court date. Failures to appear the past 2 years is 0.
That's weird.
Attorney Smith, can you just hold on one moment? We're getting some feedback. If the moderator can mute the classroom, I think it's coming from there. Thank you. You may
Sure, Judge.
proceed, Attorney Smith.
Thank you, Judge. While Mr. Glass does indicate a score of 3, I should say, on the failure to appear scale, I would note that he
Peggy.
does not appear to have ever missed a court date. He has 0 failures to appear in the past 2 years, none as well older than 2 years. So I think the court can be confident that he would appear for any court dates upcoming. In this matter, the PSA also does recommend that he be released on conditions of weekly reporting. So again, notwithstanding the fact that he is detained on the indictable matters, we'd ask the court to consider, given these are disorderly person and petty disorderly persons in nature, we'd ask the court to adopt the recommendation in the PSA that he be released on conditions for this case while it is pending.
All right, thank you very much. This matters before the court on the state's application for the defendant's pretrial detention. The court has considered the exhibits marked into evidence as well as the arguments of counsel. The defendant has been charged with 1 count of contempt, disorderly persons violating a domestic violence restraining order, and 1 count of petty disorderly persons harassment, communication, in a manner to cause alarm. The state has argued that the court should deviate upward from the PSA recommendation of release on weekly reporting and should detain the defendant, focusing on the alleged repeated conduct of the defendant regarding this victim. And also that the defendant was subject to a no contact provision, not only through the temporary restraining order, but also through this court's order from September 9th of 2024, at the time that the alleged efforts to communicate with the victim arose. Defense counsel has argued that this court should follow the PSA recommendation of release on weekly reporting, notes that they are disorderly persons and petty disorderly persons offenses. Also notes that the new violent criminal activity flag is not raised in this matter, that the defendant has no prior violent convictions. Even though the defendant scored a 3 on the failure to appear scale, the defendant has no failures to appear older than 2 years or in the past 2 years. The court does give heavy weight to the lack of failures to appear ever, and the lack of a violent
My new job
conviction.
title someday.
However, this court does find by clear and convincing evidence that no amount of monetary bail, non-monetary conditions, or combination of both would reasonably assure the eligible defendant's appearance in court when required, the protection of the safety of any other person or the community, or that the eligible defendant will not obstruct or attempt to obstruct the criminal justice process. This court will deviate upward from the PSA recommendation of release on level 3 pretrial monitoring.
How often does that happen? The judge is like, no, we're going more. We're going to hit you harder. I don't care what that report says.
And will detain the defendant. I grant the
Remanded.
state's motion and I make the upward departure for the following reasons. The defendant scored a 5 on the new criminal activity scale. This is the second highest possible score on that risk scale. The defendant was subject to both a temporary restraining order and this court's order from just September 9th of 2024, which included a no contact provision. This court's order stated that defendant shall have no in-person, mail, electronic, telephonic, or other contact with the victim BF of the offense while detained. Defendant shall not cause any other person to harass, pressure, or threaten the victim. These charges arose from repeated contact, 3 by someone identified as the defendant calling collect from the Ocean County Jail and requesting to speak to the victim. And this was just the day following the prior detention hearing and this court's order of no contact. Further, this court notes that the underlying charges which resulted in the original detention order involved the same victim. They're pending charges of stalking and contempt, a knowing violation of the restraining order, as well as terroristic threats. There appears to be no conditions that this court could impose that would protect against the obstruction of the criminal justice process by this defendant, as this defendant was subject to 2 separate orders prohibiting contact with the defendant, and the defendant was detained, yet he made repeated efforts to speak with and contact the victim. Further, the defendant is currently on probation out of the state of Tennessee. This court
Probably not.
notes that the defendant's probation in Tennessee was revoked in 2018. In 2003, the defendant's probation was declared unsuccessful, and the defendant's probation was revoked in that matter as well. And this court gives moderate weight to the defendant's charges out of North Carolina from 1997 to 1999, which include charges and convictions for selling explosives without a license, unlawful transportation of explosives, failure to secure explosives, and selling explosives without identifying the buyer.
Yikes.
The court also gives heavy weight to the defendant's prior indictable convictions. The most recent convictions are from 2018 out of the state of Tennessee. They do include possession of a handgun by a convicted felon. And this court gives heavy weight to the defendant's convictions out of the states of Georgia and North Carolina for receiving, possession, or transport of a firearm and possession of a weapon of mass destruction. As mentioned, the defendant has been incarcerated for 14.
What weapon would that be, guys? I don't know if we're just fine. Just type it. What weapon of mass destruction could it be? Hold on. Wait, what types? There are 5 different types of weapons of mass destruction: chemical, biological, radiological, nuclear, and explosive. So we think it's explosive because he already has explosive charges. Charge. Oh, that's not what that meant. I thought it meant the charge, but no. What?
14 days or more on 9 separate occasions between October 1997 through July 2018. This court gives moderate weight to the defendant's 9 prior disorderly persons convictions between 1997 and April 2002. Although they are remote in time,
Thank
the
you,
bulk of the
Donald.
disorderly persons convictions do involve explosives. This court also notes the defendant's criminal history includes convictions out of multiple states: South Carolina, North Carolina, Tennessee, and Georgia.
And now Jersey.
This court is satisfied that the alleged repeated conduct regarding the same victim demonstrates to this court that the defendant poses a danger to the victim and the community, and that the defendant would not abide by any order or condition this court would impose to protect against the risk of obstruction of the criminal justice process. All right, is there anything further regarding this matter from the state?
Nothing further, Your Honor. Thank you.
Anything further from defense counsel?
No, Your Honor, thank you.
All right. The state did not
You don't get to
request
talk,
it,
dude.
but the court is going to add a no contact with the victim provision in this order. The court notes that the prior order does have no contact with the victim. And
I think if you commit crimes in 5 different states, you get the 6th one for free.
minute. The defendant shall have no in-person, mail, electronic, telephonic, or other contact with the victim of the offense, and shall not cause any other person to harass, pressure, or threaten
Screw
the
him. He
victim.
doesn't get to talk.
The defendant's next court date is October 22nd before Judge Einbinder at 9 a.m. As also mentioned, the defendant is also subject to a no bail detainer under Complaint Warrant 2024-276-1518. That will conclude the matter of State versus
If
Carl
only.
Glass. Mr. Glass, you're free to leave the room.
Yeah, get out of here. Go. Get. Jeez. He's Jersey. He's right near me. He's locked up though. I just want to go find her and like bring her to Pennsylvania and hide her because he's oof. Jeez. Wonder if she would mind living in a van. Actually, I wouldn't mind living in a van if it meant someone in the world that doesn't know me is hiding me from him. Gosh, what a bad guy. Okay, the next piece we're going to is obviously Fozzie's drone footage. Abso-freaking-lutely. Absolutely. You're leaving Discord? Oh no. Hold on. I turned the sound off, Fozzie. Of course, it went over here. Okay. Fozzie lives in Texas. If anybody wants to know his real address and phone number, just let me know. I'll send it to you. And he did a nighttime drone showing of Texas. Hold on. I'm going to do my best real quick to give you more information. Maps. Nope. Just an approximate location, Fozzie. Don't worry. Don't worry. Like where this is compared to like, I don't know, another major city in Texas. Hold on. Okay. So I'm trying to. There we go. I'm going to zoom in. Here I go. I'm going to show it to you. I am, guys. I am. Okay, so here's Houston. Okay. This drone footage is around here somewhere. All right. Just down around here somewhere. That's awesome. That was awesome. That was great. I wonder what that guy got pulled over for. Okay, so the next one we're going to go to is Goggins. I didn't see this yet. I don't know if it's good or bad, but La Casa told me I had to get this. I had to get this. So this is my third attempt of getting this, and this is straight from the YouTube channel because I tried to record it twice, and messed up twice. Not my day for technology, just not. So at any second he can take this down. So hopefully we can get through it. Hopefully we can get through it. I think it's good. I don't know. I didn't watch it. All right, La Casa, I'm trusting you. I do trust her.
Yes, Judge, I'm here.
Hey. Well, I'm getting your file. I guess I'm being handed the other
Pronounce that name.
file for Mr. Hall. Mr. Hall, let's do yours real quick. Portfolio recovery versus Timothy Hall. Didn't have your motion for, I looked at your motion for reconsideration. At least that's what I called it. It was defendant motion for reconsideration. I guess it did not appear, but I've gone through it and court does not require personal appearance anyways with a reconsideration. I've gone through with your statement of facts, the whole thing, and denied the motion at any rate. Okay.
So it's denied?
Yes.
Oh, I got
On
the
what
other
ground?
guy.
I'm sorry?
Just
I've gone through the
see.
motion because I made a decision back whenever I made the original decision. Let's see, where was it?
Hey, Susu.
Seemed like this one was like a long time ago, but let me just get the pleadings here. Oh, it was a motion for summary disposition. Summary disposition was granted August 27th, 2024. I went through all the pleadings, found there was a genuine issue of material fact. On that date, the pleadings are in order and nothing's changed with your motion for reconsideration based on everything you stated. Nothing's changed. I don't find any.
Well, actually,
I'm sorry?
I said under Michigan law, it says that
Went through motion for summary.
Excuse me?
Go ahead.
I said under Michigan law, unexcusable neglect is often the most common ground for seeking reconsideration. I even put the statement why I asked for reconsideration due to a heavy workload at work.
No, that's not going to work for me for a summary disposition motion. Just not going to work. There was no response to the motion for summary disposition originally.
There was a response when I filed it.
You filed an answer, I believe.
I filed a motion in opposition to plaintiff's motion for summary disposition on the 23rd of August.
And we went through that, didn't we? Did we go through all your paperwork? I know I'm sure we did. Let's see here. Yeah, your pleading was captioned response to plaintiff's complaint. Is that what you're talking about?
Yeah.
That's not a response to the motion for summary disposition. And I went through that. I took that in consideration anyways, but that was for the complaint. That's what I consider an answer to the complaint. I went through that on the date for summary disposition. Remember?
So you said my response was invalid to the complaint?
No, I took it into consideration when I reached the original decision.
Oh, so you took my response into consideration of the complaint?
I did. When you filed that July 10th, 2024.
Yeah, I filed it Thursday.
The motion for summary disposition was heard August 27th. And I also had, you had a filing that was labeled, I don't even know what it's labeled, statement of, oh, here it is. Opposition to, yeah, this is it. This is one you're talking about. Opposition to plaintiff's motion for summary disposition. And we went through that on the day of the summary disposition motion. I went through all that.
Yep, and I didn't file it within the 5 days. I was working, had a heavy workload, so that's why I filed the reconsideration.
And I took all the pleadings into consideration when I reached my decision, even though you weren't here, which you should have been. Okay, my order still stands. Summary disposition is still granted. You can, if you want to appeal me, you can appeal it, but find that there's no genuine issue material fact based upon all the pleadings. Okay.
All right, I'm not in agreement with the ruling, but that's okay.
No, I understand. I appreciate your civility too. I do. But I appreciate what you're telling me. Okay.
I appreciate your time and attention today, Judge. No problem.
You too, Mr. Hall. Good luck to you. All right. Okay, Mr.
Okay, that might have been it. No, I didn't lose the internet again. Are you guys having problems? I don't even see a little thing warning me that I'm having a problem. So I don't know if that's what she was talking about or if it's this guy right here. I thought it was this guy right here, but that was pretty good. Maybe that's what she was talking about. So here's what I'm going to do. I'm going to play this guy right here because we're here. He's here. I have buttons I can press. And if it's boring, it's fine. You'll be fine.
Belzer, I think we can go on yours. You have Jack D. May revocable trust versus Taji Miller.
Yes, Your Honor, I'm here.
Ready on that, Your Honor.
Right. Mr. Belzer, do we have witnesses?
Just Mr. May, but I don't think any of the facts are contested.
Okay, let's swear him under oath anyways in case we do, I guess. What May, why don't you read? Do you swear from the testimony you're about to give will be the truth?
Yes.
Okay, just in case. So you're under oath in case we come back to a question. Mr. Belzer, go ahead and tell me what may not be in dispute, I guess.
Judge, his property is owned by a trust. Mr. May is the trustee. And this property was sold under a land contract to his son, Brian. Brian May then entered a contract with Mr. Miller, a lease agreement. Apparently, Mr. Miller prepared, but it was a 61-year lease on a house for $1,000 a month gross. Mr. Brian May lost this house. He was not making the payments, gave a deed in lieu of foreclosure, and we now own the property. We've had no dealings. We entered into no agreement with Mr. May. He's there. He's subject to numerous felony charges, possession of a firearm, felon third time, but real important here, maintaining a drug house, and it's a bunch of drug charges he has, cocaine. And in any event, we have no relationship with him, never entered a contract with him. He's just there under a prior owner. We just want the house back.
Okay. And Mr. Miller, did you have a lease agreement with Brian May? Is that right?
Yes, Your Honor, I do.
Okay, so why don't you raise your right hand just so we go this way too? Do you swear from the testimony you're about to give will be the truth?
Yes, Your Honor, I do.
Okay. And Brian, when did you enter into a lease agreement with Brian May?
I entered this lease agreement with Brian May on July 1st, 2024.
I'm sorry, what was it? July what?
July 1st, 2024, Your Honor.
Oh, just this year, July 1st, 2024. Was there a written lease agreement of some sort?
Yes, Your Honor, it's a written agreement.
Looks like it's the one I got in the file, I guess. Mr. Belzer, have you seen it? Just so we know.
Yes, Judge.
Yeah, Michigan residential lease agreement. Okay.
Your Honor, I don't mean to interrupt. If you look at number 32 on the lease at the sale of property.
So at 32. Sale of property. Owner does not have right to terminate this agreement. I don't know that that's going to be binding. Who's Mr. Belzer, then on this July 1st date that I guess this residential agreement, who owned the trust on that date?
Mr. May did, Jack May.
Thank you.
But the property was owned by, under a land contract to Brian May. Brian was buying it under a land contract at that point.
Oh, it was under a land contract. I got you. Okay. Land contract. Do I have the land contract here too or not?
No, Judge, I don't believe so, but you should have a copy of the deed that Mr. May took the property back. And that deed was dated August 14th of 2024.
Where's that? Oh, it looks like it was a quitclaim deed.
Yes.
Okay. Well, with it, let's go to the land contract first. So was that in writing? Was there a land contract? It had to be, I'm guessing.
Yes.
Do you have it?
No, Judge, I don't.
Is there, I'm Mr. Let's do it this way then maybe. Mr. May, was there a land contract at one point between you and I guess your son, Brian?
There was, yes.
Okay. Did somebody draft the land contract for you?
I did.
Oh, you did it?
Yeah.
Do you have a copy of it someplace?
I don't. It's been 20 years. This was my son. It was something because we move all the time. I may be able to find it, but it would take a long time, to locate it.
Okay.
My son has lived there. He basically has never, this is a house that I wanted to furnish, hopefully my son has some alcohol and drug problems, but that was before then. I was trying to get him enthused or to get him, and to furnish him a place to live. He's basically never paid to live there. I've been paying the taxes, everything. We basically, my son today, we have to basically support him. So we never did anything on the land contract because it didn't really matter until it's come up. So furnishing a place for my son to live is one thing, but furnishing a place for Mr. Miller is totally something different.
Under the land contract, then was it ever recorded?
No.
Okay, so it was just agreement between you guys on paper at that point.
We did it on paper because I don't think there's any requirement that it has to be recorded. We did do a memo. I did the deed transfer statement to the township at the time that we did the land contract.
Do you know, I'm sorry, I didn't mean to cut you off. I'm just kind of thinking.
The transfer affidavit at the time that we did the land contract, that was filed at the township, but we have a copy of that.
Okay, was there any provision in the land contract that said that Brian May could not encumber that property until he actually owned it?
Yeah, it was standard language,
Yeah,
Judge,
it
and
was
yes,
a-
in fact, and that was in 2006 when that contract was done. And it was the standard language in the contract that, right, he had no rights over and above, and Mr. May, Jack May and the trust had the right to mortgage the property or whatever, but Brian's interest was subject at all times to the premier prior ownership rights of the trust. And so, yes, there was a restriction in that regard, Judge.
Okay, is that true, Mr. May?
Yes, it is, yeah.
Okay, okay. So back to you, Mr. Miller, how did you enter into this lease agreement with Brian May?
Your Honor, I entered the lease with my landlord, Brian May, and I actually paid up rent in advance. I mean, I don't know what's going on here.
When was the last time you paid rent?
I paid up rent on 7/8/2024. I actually have a receipt too. I have kids in the community. That's why I took so much interest in the property.
How much did you pay on July 8th then?
Your Honor, I paid Brian May $144,000 in cash.
What?
But no cash?
Yeah.
What? Wait. He paid $144,000 in cash for rent. Dude, why don't you just buy a house? He paid. Okay.
Yes, I did. It's cash, Your Honor.
And you've got no receipt.
Yes, I do have receipt.
Judge, Mr. Brian May was involved in drugs. Mr. Miller is charged with being a drug dealer. We suspect this is all just.
Yeah, what?
Your Honor, Your Honor, I never received the notice to quit.
Why would you pay 140? I got a question though. 144,000 when your rent monthly payment's only 1,000.
I paid rent up in advance because I have kids in the community, and I took interest in the property because I have kids in the community.
That doesn't make any sense. Why wouldn't you just continue to make a $1,000 monthly payment?
That's what me and the landlord put together.
So where's your receipt?
It's written on this Joker.
My landlord has a copy.
Hold the receipt up for me.
There you go. His signature is actually on here.
Have you ever seen this receipt?
No, Your Honor. I mean, this is it's kind of absurd. The whole thing, the 61-year lease. Who's going to pay $144,000 in rent? I question whether Mr. Miller, how he had $144,000. He has an appointed attorney for all these criminal cases. This is just fairy tale stuff.
Okay, so I can't see.
Okay, this lawyer needs to stop. I know the judge knows better, and the judge isn't listening. But you can't ask where he got his money from. You can't say he's a criminal. So he got it from drugs, and I mean, you just can't say that. He has zero proof any of this money came from drugs, if there was any money. So those receipt pads you can buy at Office Max or Staples for like $5. I use them all the time in my other jobs. So you just write on them. And Brian May's signature, I don't know. That's where he should be focusing on. But what?
The whole receipt though is the problem.
Here you go, Your Honor.
Slide it over for me from there. Actually, yeah, hold it up vertical like that for me. Maybe that we can do it that way. Let's just see.
I could actually bring it into you, Your Honor.
Now hold on. July 1st. Go pull back a little bit. Pull back a little bit. There you go. July 1st, 2026. 2026. There's that 4.
It's a 4.
I don't understand what that says from. It's go down a little bit now so I can see the other side of it. Just go downward with your. There you go, just like that. Taji Miller. Where's Brian Miller's May's signature at the top there?
I'm not for sure.
Not for sure.
You see it?
Well, kinda. Why isn't his signature down below or anything? Why is it at the top of that thing?
I'm not for sure. That's
Sure.
where he signed it.
I gotcha. Where did the money come? Where did you pull the money out from? It's all cash.
Your Honor, I worked a lot of years. I actually been shot in my arm, so right now I'm waiting on disability. But up until 2023, I worked a lot of years. I saved up a lot of money.
And he was in prison.
And I still have some money saved. And to answer the attorney question, my lawyer is Michael Ewan, and there is no drug activity or illegal activities going on in this residence at all.
Let's see.
Judge, certainly Mr. Miller can sue Brian, May, if he thinks he's entitled to some money back. But I mean, that's just absurd. Brian May has no money. He's living in his dad's basement. He's homeless, basically, other than living with his dad. And really, this just defies any logical, rational beliefs.
61 years. Never heard anything like that in my life. Back garage included. So 61 years. So you were to pay. Where's my calculator here?
I'm sorry, I don't know.
61 years.
Your Honor, I paid rent up in advance so I could focus on my kids in the community. I have 2 teenage boys that's in the community. They stay maybe 3 miles away.
Times 1,000. So the total you were going to pay over this whole thing was $732,000 for this place to rent.
Yes, Your Honor, I'm a felon, so it's hard for me to get housing in some places.
For $732,000, buddy, it's a lot of money to put out for a house like this. That doesn't make any sense.
What doesn't make any sense?
$732,000 in rent for 61 years. How much was, let's see, you gave him $144,000, you said, right?
Yes, sir.
144.
Judge, it's about a $250,000 house.
Well, I haven't looked into the market of the house. I just took the opportunity because my kids live in the community and I wanted to be around for my kids. And I'm also a felon, so it's hard for me to get housing. That's why I took the opportunity.
Well, if you had that kind of money, you could find a lot of housing anywhere. I just went through a whole stack of ones anybody would allowed you to.
Well, for the property,
Yeah.
for that.
I don't think that it's not making any sense to me. 144 months. So divide by 12. So how long were you for that money you gave him? How long were you planning on staying there? What was that worth?
The 144,000 was for what is that? 10 years or 10 or 11 years. It just gave me advance to concentrate more on my children that's in the community.
Well, no, you got to tell me how many years you planned on being there for that 144,000.
Does anybody know where his kids live?
I plan on being here for the whole 61 years. The 144,000 was just for 11 years or 12 years, Your Honor.
Yeah.
It wasn't just a one-time payment or anything. I still got payments.
Yeah. Well, I think you're right. I think your actions against the person that we were renting to, Brian May, looks to me like the owner actually is the trust. Did Brian May ever tell you there was a trust?
No, Brian May didn't tell me it was a trust, Your Honor.
No? Did he ever tell you that he was that he claimed it back to that trust at any time?
He never told me that, Your Honor. I also never got a notice to quit or anything.
Yeah, and it sounds like you had 12 years of rental property, didn't you? According to what
Yeah. I paid him 100, yes, in advance for sure.
So it looks like your action's against Brian, because he quit claimed it back over to the trust on August 14th. It looks like your action's going to be against Brian. So it looks like.
Well, we entered this agreement on July.
Yeah, it doesn't look, everything you're telling me doesn't seem legitimate, it doesn't look legitimate. The terms of the lease don't make sense. Paying cash of $144,000 makes credibility is another big issue. Why didn't you just get a cashier's check or get something else? Why would you pay cash for something like that?
Yeah, and then again, I'm a felon. It's hard for me to get housing. And then plus,
After the cashier's check, it's not.
That's just the way I went about it, Your Honor.
Yeah, boy, you kind of made a big mistake there, I think. Really. That's a big problem.
No, he didn't.
Mr. Belzer, I'm sorry, I kind of took over for you. I'm kind of trying to figure out what was going on. Give me your argument why I should rule in your favor, I guess. Go ahead and give it to me.
Because we own the property, and nothing that this Mr. Miller is saying makes any sense at all.
Yeah.
And really, it's just beyond belief. A 61-year lease, all the terms of this lease are so goofy. No attorney in their right mind would ever go along with any of this stuff. And plus, Mr. Miller doesn't have, and I believe this is just some drug transaction where Mr. Brian May never had $144,000 in his life. Within a month after this, not even that, well, yeah, it's probably been 2 months after this transaction that he gave the deed back to his dad because he had no money, nowhere to live. And we own the property. We have no relationship with Mr. Miller. We ought to get an order to take possession of that property, Judge.
Your Honor, if I may, I'm going to ask Mr. Miller if the court will allow me, because I have at least advised Mr. Miller in this case. It's not a case I intended to represent, but if Mr. Miller will let me say something, I would like to try and. I have one concern in hearing this, and I don't disagree with Mr. Belzer that if the land contract prohibits Brian May, from encumbering the property, then they are right that they are the owner and he can't do that. I would just note that no one has presented that land contract to show that. And I'm sitting here with the Cameron's real property book that says unless there's an explicit clause prohibiting encumbering the property, that a vendee on a land contract has an absolute interest in the property to encumber it. So as just a candor to the court and having represented Mr. Miller, at least on advice on this matter, I can't just sit here and just let this go this way without them at least showing that there was a land contract that said he can't encumber it. I get that the terms can be crazy. Commercial buildings enter into leases for 50 and 100 years. I can't speak to why Mr. Miller would enter such a lease, but if they can show that Mr. May didn't have a reason or ability to encumber it through that land contract, then I think their position is absolutely correct. But absent proving that, I think Mr. May is at least a necessary party to testify to say.
Well, that was going to be my next, Mr. Lowry, thank you. And that was going to be my next question. Mr. Miller, do you have any witnesses or anything?
Yes.
Well, where was your witnesses at? Today.
They here. I can call them.
Who?
Sharika Lewis.
Who's that?
That was a girlfriend of mine.
You know Sharika.
I'm talking about somebody involved in the contract.
Judge, if I could
The
interject
contract,
something
the
here.
contract is a legal document. You want me to call Lindsay Markle?
But the concern I got is pretty much what Mr. Lowry's is suggesting, that if I go back in time here, there's an allegation that Brian May had a land contract, correct? Where I've got nothing that says anybody's got any land contract. Who was giving the land contract?
Judge, if I may. So first of all, you do have sworn testimony as to what the terms of that land contract were. Second of all, this defendant has no right to have free legal advice. If he can come up with $144,000 in cash, he should not be getting legal aid advice.
That means nothing. This
Nor should he have.
I would object to that, Your Honor,
attorney
just on the
that
basis that Mr.
court.
Belzer doesn't know our priorities and our qualification criteria. So
Yeah.
But
Or him.
in any event, really, you have sworn testimonies to the terms of the contract.
Here's my concern though. If it all hinges on what right Brian May had, period, whether he owned the property, did not own the property, and it was my question that I asked about having some kind of encumbrance, some kind of paragraph that says you can't encumber the property if it's a land contract. Right now, I got nothing all the way around, period. I got nothing. So who owned who owned the property before Brian May if that land contract is not there?
I did. I have
The
a receipt
trust
right
that
here.
Jack May.
Well, actually, my corporation did initially, and then I assigned it from the corporation to myself. When I bought the property in 2004, built the house, and then sold it to Brian specifically because it was a father to son and to provide him housing.
Right.
We've held title since 2004.
Either
My corporation or my trust has had title to that property since 2004.
And then at 2004, what shows
In
up?
2004, it was a vacant lot. I'm
Yeah.
a home builder, so we built a house. There was 2 lots there. We built the one, we sold the one house. The other one, it was to the point where I basically furnished someplace for my son to live.
Mhm.
And basically, I was hoping my son had bad alcohol problems. I thought he would get out of that. He was actually, you could live and work with him when he was an alcoholic. Around 2017, it went from alcohol to drugs. I don't know if Mr. Miller has anything to do with that or not, but he got into the drugs and all of a sudden, but I've been basically paying the taxes on it for years. It's basically been my property. It was something that I did for my son to live in. I don't think that my son signed that receipt to, he can,
Your Honor, Brian, I don't mean to interrupt. Brian May been paying the taxes on the home for
Hold on,
years.
Taylor. Hold on. So,
furnishing, like I say, furnishing a house for my son to live in is one thing. Furnishing a house for Mr. Miller to live in is something else.
Yeah.
I don't do rentals. I have never done any. Even if you look at that lease, if you look at the first page, I don't even think it was for 2085 or whatever it was. It looks like they changed the
Thought it was just
number
for a
from
picture
a
of the house.
from a
Fonzie.
4 to an
Yeah.
8. My son does some really dumb stuff, but he would never even have done anything this crazy.
well, I think there's just too many pieces for me to kind of speculate on right now, quite honestly, for everybody's sake.
I just want to ask, Your Honor, just with Mr. Belzer. So there was no writing done whatsoever in the terms of the land contract to Mr. May?
Yes,
there was a written land contract.
Yeah, in 2006, there was a written land contract.
So all I would say is that land contract should be produced. I understand Mr. Belzer's position that there was testimony given to the land contract, but I would point to the best evidence rule. The best evidence of a land contract, if there's a written land contract, is the land contract. And
that's
again, we'll concede that if that says that Mr. May could not encumber the property with a mortgage or a lease or anything like that, then I think plaintiff prevails undoubtedly. without question. I just think the lease should be, or the land contract should be produced.
Right. I agree. And I think honestly, and that's kind of, I'm kind of going around and around on this thing. It's just too much speculation for me just to kind of say, okay, you got this, you got this. When it all encompasses either a land contract or no land contract, I think we're going to adjourn it one way or the other, give both sides a chance to produce whatever evidence they got. All the way back, even in case there's a decision and just the register of deed action, wherever the original title on the property is, so we can kind of have a chain of title somewhere. And then this land contract, if you've got any kind of proof of that land contract, whatever it is.
Okay.
I think we can need some time to look at that. And same thing with you, Mr. Miller.
Yes, Your Honor.
And then somebody, quite frankly, is Brian May, is there some reason he's not here today?
Well, I could have had him here today. I didn't see the need. But
Yeah.
We'll have him here for the next time, Judge.
Okay.
And then again, Your Honor, I never received a notice to quit. I believe that's.
Well, let's not get too far ahead of things. First, you're claiming this rental agreement sitting here. And you're claiming that you made $144,000 in cash towards it.
Your Honor, I will bring the receipt down to you.
Well, yeah, do that for me anyways. At least make
Yes.
it, and keep a copy for you as well. But Mr. Belzer's going to want a copy of that.
He can just make another copy. Don't worry. He has plenty of copies. But dude, you owe that lawyer like at least $100K for what he just did for you.
Too. Okay.
Right. And
Okay.
Judge, I'd also like to get, and I can send some
No, you should.
requests to Mr. Miller, where this $144,000 was at. I mean, I'm gonna hear that it was in a shoebox in his bedroom someplace, but
Your
he
Honor,
was
that's
in
another story
prison.
for another day.
Your Honor, I would just point out for Mr. Miller's position, I don't know that there's any relevance to where that money comes from, whether he
Absolutely.
got it from winning the lottery or he got
Well,
it
yeah,
from collecting pennies in a jar, or I don't know that the relevance of where he came up with the funds to pay it is frankly relevant at all.
Right? It's discrimination. What's going on?
Hold on, guys. Hold on. And Mr. O is correct, other than if it goes to any kind of credibility, I'll have to rule on it later on. Yeah, honestly.
And I'm not taking a position here nor there about what the validity of the receipt or if the money's. I just don't think where the money came from, whether you know.
I'm not trying to brag.
If there's money and he claims that he has paid the money, I don't think it matters where that money came from, whether he was working at 7-Eleven or doing what.
It may go to credibility, it may not. I'm not going to make any just speculating decisions on any of it. So let's do this. Mr. Belzer, why don't we do this? Because this is going to be more than just this. Why don't we open up discovery, allow discovery for a period of time? How much time do we need for anything at all? I mean, it should be short anyways. I mean, if there's nothing, we got
2
nothing.
weeks. Judge, I'm leaving the 26th and will not be back until October the 5th. So if we're gonna pick a date, I can't be here for those dates.
Okay.
Yeah, Your Honor, I'm ready to proceed. I don't know what's going on. All I know is
Mr. Miller, it's to your best interest if we adjourn it for a bit. Because if I make a decision today, I'm speculating on a whole lot of stuff, and I'm not going to do that. So let's adjourn to. I'm sorry. If we do, I'm sorry, Mr. Belzer. When are you gone again?
The 26th of this month until October the 5th.
And
So what we got beyond those?
Robbie,
We can either do next week, or we can do it October 8th is when, after you get back.
Ren, look at you all green.
Next week will be fine.
Okay, so we'll set it on for next week, September 24th. And let's just set a different time, because I'm sure this is gonna be like, yeah, let's do 11. 11
And,
o'clock.
and Your Honor, at this time, we have not entered an appearance because we were not going to represent, but I am going to take this back to see if we can in fact enter a full appearance beyond advice. So if I do, I will make sure I get an appearance to the court and to Mr. Belzer.
Okay, cool. That's perfect. So we'll just, leave that open and I will hopefully, quite frankly, it'd be helpful if we did have, but we'll just leave it at that. I'm gonna leave my notes here and
Yeah, you know I'm not gonna mark
we'll
it
see everybody next week.
Okay, thank you, Judge.
Thank you, Your Honor. You have a good day.
You too. You too, guys. Bye. Bye.
Twitchy, I love him though. I love him. Oh, okay. La Casa. I don't even know if you watch my stream. I see you and Judge Fleischer stream all the time, but thank you so much for that. That was awesome. I enjoyed it. It was a roller coaster. I laughed, I cried. Whew. Now it's time for us to normalize, guys. Normalize. Oh no, wait. I'm missing something. Some judge is hitting on Lease. Hold on, hold on, hold on. Listen, I'm going to put Judge Fleischer on while I run upstairs and get this judge because there is literally a judge hitting on Lease. And Lori, love, you are not going to like it. You are not going to like it when you find out which judge is hitting on Lease. I'm telling you. Let's play Judge Fleischer. Please be good because I'm stepping away from my computer for a second. Hold on, hold up. I got to say thank you so much to Louise. Thank you, thank you, thank you, thank you. Make it green. All right. Yeah, there's a judge hitting on Lease. I'm going to go get it. I'm going to go get it. First, let me put some top quality content on for your entertainment.
You ready? Let's roll. Okay.
Let's roll, nerds.
First judge is page 1. Adolph, Matthew, come on up.
Yes, sir. Good morning, Mr. Adolph. Sir, you're charged with interference to the duties of a public servant. You're facing up to 6 months in jail and a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you, sir.
What is your honor? What's his last name?
Adolph.
Yeah. ADOLP. On September 9th, 2024, officers were dispatched to 6010 Gnarled Oaks Court in Harris County, Texas for a family disturbance. Officers made contact with the witness. The witness stated the defendant was intoxicated and fighting with her mother. The witness stated her mother exited from a bedroom where she had been arguing with the defendant, and the mother had a bloody nose. The officer made contact with the witness's mother, who stated the bloody nose was from a sinus issue and that the defendant was in the backyard. The officer
Who said that
the complainant's mother said that it was from a sinus issue.
So she says that.
She says that.
Okay,
yes.
good.
And the officer attempted to speak with the defendant, who became belligerent, was cursing, yelling, and the defendant demanded the officer leave the property, cursed some more, and stated, "Fuck you, get off my property. I'm gonna get Facebook a live stream. You know what? Fuck you." The defendant attempted to enter the residence and slammed the door on the officer. The defendant was identified with atheist.
Who called them out there again? Did the complaint mom call them out there?
No, it was the daughter of the mother.
Okay.
So
because he was being belligerent,
yeah, he was arguing with the mom, so she called him, and then as the officer later attempted to make contact with him and detain him, he retreated to his residence and slammed the door at the officer.
Did they eventually get to him and arrest him, or what happened at that point?
Yes, they were able to.
Mr. Adolph, I'm going to find that there's probable cause to go forward with the case. I'm now ordering you as a condition of your bond not to consume alcohol anymore.
Sure.
It's a condition of your bond. If I find that you're consuming alcohol, I'm going to put you in jail. Make your bond $5,000 to $10,000. You need to understand that if you don't have anyone that's gonna pony up that kind of money, you'll be stuck like Chuck in there until this case is over with. I don't want to have to do it. So just understand, I'm gonna monitor you. I'm gonna have you taking drug and alcohol tests. If I find that you're doing it, that's it. So do you mind doing me a favor? Reach out to the complaining witness, let her know that we've made a condition of his bond that he's not to consume alcohol and to let us know if he starts using.
Yes, Your Honor.
Please.
Yes, Your Honor.
Are you still living with them?
Yeah.
Okay, I'm now ordering you also as a condition of your bond, not to have any threatening or harassing contact with them as well. What is threatening or harassing is not what you think. I could care less what you think. It's what they perceive. So I don't care what you think is this, what that, no. It's how they, like exactly what I'm saying, how they perceive. So can conduct alone violate this court order? If I go like this, is that threatening or harassing? It most certainly is. So be careful because you're the one that's going to end up in jail. What do you do for a living?
I'm a service technician for oil and gas, General.
You have a full-time job?
Yes, sir.
And how much money you make a month?
Maybe.
Okay, you need a lawyer to represent you. We're going to reset your case to give you time to hire a lawyer. So what I'm going to have you do is I'm going to have you go to Victoria, sign a reset. After that, I'm going to have you meet with Rachel for your bond conditions. After that, we're going to let you go. Be careful out there. You know, there are people that when they drink, they become very happy, like little bunnies jumping in the woods. And then there are people that when they drink, they get horns, they develop a tail. And if that's you, don't drink. Because why does everybody else have to suffer because you're drinking? Get the hint? Good. That way.
Right this way. All right, Judge, next is case 15, Martinez, come on up.
Oh,
Martinez Torres.
okay.
Never mind. Go ahead and have a seat. Martinez Carlos.
Oh,
Maybe they didn't hit the like button
Is
because
this
they don't like my
Martinez?
stream.
Page 15.
Maybe that's why they're not hitting the like
Martinez
button.
Carlos.
Okay. All right. Good morning, Carlos Martinez. So you're charged with assault of a family member. You're facing up to a year in jail and or a $4,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you, sir.
On September 9th, 2024, officer was dispatched to a family disturbance call for service at 1531 Old Greens Road in Harris County, Texas. Upon arrival, the officer made contact with the defendant, who was seen attempting to kick the door down at the residence. The defendant said, "Shoot me," to responding officers. In attempting to detain the defendant, he began to actively resist detention. Upon detaining the defendant stated he was kicked by the complaining witness, his sister, and they began to have a verbal altercation. The defendant advised that he was assaulted by his older brother. The defendant advised he was punched in the face and locked out of the residence. Contact was then made with the complaining witness, who advised upon arriving to the residence, she asked the defendant if he was going to pick up their little cousins from school. The complaining witness advised she was ignored by the defendant, and the complaining witness stated she pretended to kick the defendant to get his attention. The complaining witness stated she did not make any physical contact and was just trying to play with her brother. The complaining witness then asked the defendant again, which caused him to tell her to shut up and proceeded to slap her left arm with an open palm. The complaining witness advised she went inside the residence and advised her mother, the witness, about the incident. The complaining witness stated this caused the defendant to get more upset and attempted to assault the witness. The complaining witness stated she got in between the other witness and the defendant began to punch her multiple times. The complaining witness advised in an attempt to defend herself, she began to hit the defendant back. The complaining witness advised their oldest sibling, the second witness, then attempted to push the defendant away from the complaining witness and the first witness. The complaining witness stated this caused the defendant and the second witness to begin fighting. The complaining witness stated they were able to push the defendant outside the house, and the complaining witness stated
So he next started fighting with the other one.
with the other one, yes, Your
Go
Honor.
family brawl.
Yes, Your Honor. And the complaining witness stated she felt pain and discomfort.
Is there any kind of alcohol or dope that we should be aware about?
There's no allegations that against Your Honor.
Mr. Martinez, I'm going to find that there's probable cause to go forward with your case.
polka dot shirt for the
And
win.
does he have any criminal history?
No, Your Honor.
And is it a juvenile,
I'll check, Your Honor.
please? So I want you to understand that there's a protective order that has been issued in this case. Let's see if it for both.
No, sir, no juvenile.
I see that the protective order just is over one person. Should we do one on the second person as well? What say you?
At the moment, since the second person is a witness and not a complainant.
No, he started, but, well,
I feel pain and discomfort because I'm in my 50s.
in theory, not a complainant, but in theory, yes, a complainant, because they were fighting as well.
I think.
Do we know were there any kind of injuries on the second person as well? Mr. Martinez, at a minimum, on a protective order has been issued. You need to understand that we take that extremely serious,
Still in
and
the
that
box.
if you violate this protective order, and it doesn't matter how you violate it, even if, here, you're now prohibited from going within 200 feet of the address of where they live or where they work. Even if they call you, say, hey, come on over, let's talk about this, and you go over there, you're still in violation of this protective order, and if you violate this, they're gonna file additional charges against you, and then it really just goes sideways really quick. So I'm ordering you now, also, as a condition of your bond, no weapons and no contact with any of these people whatsoever. Do you understand? Where are you now gonna live?
Right now, since I got out of the criminal justice center, I don't know how it's called. I've been staying at 1351 Greens Parkway, Houston, with my dad's niece.
Your dad's niece. Okay,
I haven't been there since my arrest.
good. You're not allowed to go back.
Yes, sir.
Understand that we take it seriously. You go back, I'm gonna put you in jail, and if you don't have anyone to, pay all that money to get you out, you're gonna be stuck in there until this thing's over with.
Sean,
How old are you?
17.
You're 17. What do you do in life now?
I'm going to school. I'm trying to graduate. I'm doing good in school right now.
Are you in high school?
Yes, sir.
Okay, where do you go to high school?
Inmate's High School, all the United States.
If I drug test you now, what's gonna show up?
Sir?
If I drug test you now, what's gonna show up? I'm sending you now for a drug test. If you're lying to me, it's not gonna go well. Are you sure? You know better than anything else. If I drug test you now, what's gonna show up? We'll see. I'm sending you now for a drug test. I want to know what, if anything's in your system. If you have anything in your system, it stops as of today. I'm going to drug test you like crazy. And if I find that you're smoking any weed, using anything that has THC in it, likewise, I'll put you in jail. I'll appoint your lawyer today so that we can have someone advise you. But that's it. No weapons, no contact with these people until I know that they want to have contact with you. And then at that point, we'll go from there. So I'm going to send you for a drug test. You must come back, and then we'll have you speak to a lawyer. If you don't come back, I'll issue one.
When do we come back?
10, an hour. We'll send you now. Come back right after you're done. You'll be back in an hour.
Yes,
And then I'll have you speak to a lawyer. Okay? I'm going to have you go to Victoria. We'll have you sign a reset, and then I'll have you meet with Rachel, and then we'll see you here momentarily.
It'll be 4 years from now, 5 years from now. Lena's steps off the plane to see America. She's wearing white, of course, because she's pure. And we all throw spaghetti at her, and she doesn't remember this conversation, but we do. Lena's gets back on the plane and says, I'm never coming back. How dare that? Okay, speaking of Lena's, I think I'm going to need you guys to turn your volume down a bit for a second because I did not edit this. This judge is hitting on Lena's hard. Lori, I'm going to need you to lay down before you watch this so you don't fall over, and get some tissues. Here we go. Just make sure you turn your volume down. If you didn't, that's on you. Here we go.
Good afternoon, sir. Are you Mr. Henry?
That's me.
All righty. Understand your rights in court today.
Yes, sir, Your Honor.
Did you get a copy of the complaint?
Yes, sir.
Did you read it? You understand what you've been charged with?
There it is. Do y'all see it? Do y'all see it? Look at him. He's looking directly at Linus right now with his orange. He's wearing all that orange, saying, Linus, this is for you. You see that? Lori, are you okay? Listen, you slash 2 tires, I'll slash 1.
Yep.
Looks like disorderly conduct while intoxicated and persisting. It's a 4th degree misdemeanor, so it's up to 30 days jail and up to a $250 fine. Any questions about that?
No, Your Honor.
Now, you have the right to have me read your complaint out loud, but it's not required. Would you like for me to read it or no?
No, Your Honor.
Okay. How do you want to plead today?
I'd like to plead guilty, sir.
Before I can accept your guilty plea, you know the drill. I got to ask you a few questions. First and foremost is you're not required to plead guilty. Nobody can force you to. You understand that?
Yes, Your Honor.
And you realize as you stand there in front of me, I presume that you're not guilty of this offense until and unless the state could prove it beyond a reasonable doubt.
Correct, Your Honor.
Okay. You have the right to be represented by an attorney. If you couldn't afford one, we give you one for free. Was it your intention to give up your right to a lawyer today?
Yes, sir, Your Honor.
Now, whether you have a lawyer or not, you still have a right to a trial. Could be with the judge, could be with the jury. Understand?
Yes, Your Honor.
And did you know that at the trial, you could both cross-examine your accusers as well as subpoena your own witnesses to compel their attendance?
Yes, Your Honor.
You would have had a right not to testify, Mr. Henry, if you didn't want to. Nobody could have forced you to do so. And the decision not to take the witness stand would not have been able to be used against you in any way. Do you realize that?
Yes, Your Honor.
Now, plea of guilty is a complete admission of guilt. By tendering that plea, you admit to committing the offense of disorderly conduct. That means the state doesn't have to prove anything anymore. Your presumption of innocence no longer applies, and you'll give up your right to a trial and the other rights we've discussed. Understand?
Yes, Your Honor.
If I accept your plea and enter a conviction, I'm going to impose sentence upon you today. Have you been threatened in any way or promised anything to get you to do this?
No, Your Honor.
Are you under the influence of anything right now?
No, Your Honor.
Are you a citizen of the United States of America?
I am, Your Honor.
All right. I'm going to direct the officer to go ahead and provide you with an attorney waiver form. You don't have to waive your right to a lawyer, but if that's your decision, it has to be done in writing.
Yes, son, Your Honor.
Okay. Did you understand all that?
Yes, Your Honor.
Okay. Anything you want to say about what happened last night?
I was just waiting to eat something at the Salvation Army, and I guess I fell asleep in the grass, and the police told me that I was trespassed from the Salvation Army. I'm actually was waiting on a room to get in there so I can not be homeless anymore, and I got trespassed from there, so that's not good.
No,
but
are you going to go down to the men's haven?
Oh, gosh, is that not the saddest thing you've ever heard? That's terrible. He went to the Salvation Army because he needed a place to live. And he was waiting. And he fell asleep in the grass, and now he's trespassed from the Salvation Army. He can't live there. That's bad. But wait, the judge has a solution, guys. Here we go.
yeah, I have to go in there. I have to make sure I don't have any alcohol in my system to get in there. So
you want me to keep you in for a couple days so we can make sure?
That sounds good to me, Your Honor.
Okay.
You guys would make a great couple.
All right, Mr. Henry, here's what we're going to do. $200 fine and costs. I'll suspend half the fine, so it's only $100. 3 days jail, but you get credit for one already, so 2 days to dry out, and then you can go see if you can't get a room down there at Haven, all right?
Thank you, Mr. Stansberry.
Good luck to you, Mr. Henry. You may go with the officer.
Bye-bye.
All right, officer, that's all I've got on my docket for you guys. You got anybody else down there?
Yep. He's trespassed from the homeless shelter. He can't go to the other homeless shelter because he has alcohol in his system. So then, you know what? Let's go to jail. Jail will work. All right. You can turn your things up now because I'm going back. I'm going back to Judge Fleischer.
Your Honor, the OR doesn't mention anything about injuries for the witness. The only thing it says is that the witness told officers they engaged in mutual combat. That's the only thing.
What do you think? Just bond? Okay. Great. Is that her?
Yes.
Great. Can you bring her up?
Ma'am, come on up.
Hi there. Thank you so much for coming. So tell me, you work with Aldine and you're here for this, for Mr. Martinez?
Yes, he called me, to get transportation here.
Great.
Also, his sister was a student of mine, and she asked about him daily, and wants to see him.
Lori, don't blame Lena. It wasn't her fault.
So he was trying to keep her, for me to let her know I can't see him. Other family that wants to know when can he come home. And it was a civil altercation.
Right.
They care a lot about him. They love him. Mom actually had a doctor's appointment this morning. So
So let's do this. I'm sending him for a drug test now. I want to know what everything's in the system. We'll have him come back. I'm going to appoint him a lawyer. In the interim, do you have a good phone number for the family so we can have them reach out to see? Okay.
I had my computer.
Yeah, take your time. There's no rush. We're going to be here for at least the next 2 to 3 hours.
But I will let you know if he's on drugs as well. He is in a program at the school, which is GAP. It stands for Gain Appropriate Performances. It helps him with anger management.
Good.
His coping skills. And Carlos and I have had a relationship. He was my 9th grade student. He's in the 11th grade. And sometimes when he get upset, he calls me. He explains details, but I also
Hey,
let you know that.
I like that you call her. That's great. That really helps, you
What
know?
I'm listening to today was when physically hitting his sister is new for me. I know, sisters and brothers, they argue a lot, but she actually cried yesterday in the cafeteria. She said, can you please call him, please, I want to talk to him.
Mr. Martinez, do you see this?
But,
hold on. Do you see this? She's crying in the cafeteria for you.
yeah, she wants to talk to him.
You know?
He said, I can't let her know, I don't want to get in trouble. I can't talk to her. And she stepped outside. She said, Ms. Matthews, let him know that I am okay.
You know,
So that's a lot of love.
what you do now, Mr. Martinez, will impact you for the next 40 years of your life because everyone knows that you have this assault and it puts the entire world on notice that you have a trigger temper. So when you try to go get a job, when you try to go do anything in life, they're going to see this and they're going to go, well, I don't know, maybe we shouldn't give this guy a job. Maybe we shouldn't let this guy come to school here for college. Maybe we shouldn't give him this car because we know that he's liable to just go nuts. Look, it's not the end of the world. We all make mistakes. The idea is that if you make a mistake, you get up, you brush yourself off, and then you learn from it. That's why we have this. That's why we have jails, to get you to understand that there are some mistakes that you make that we won't tolerate. That's why we have jails. If a mistake is bad enough, that's where you go. This is one of those types of mistakes. But like I said, it's not the end of the world. The idea is that you get here, you learn from the mistake, and then you move on. So just roll with the punches. I'm really happy that you have maintained contact with Miss Matthews. That's great because it shows me that you care and that you want to better yourself. And that's what we want. That's what we want, is only see you, achieve greatness. That's what we want. I can make it a condition of his bond that we do darn near anything. So if you think that, doing anger management on his own, we can make that a condition of his bond that he does it. The problem is that he's only 17, right? And everything in this life costs money. And
That's not what this referring to.
right, but that only covers so much. So let's do this. First things first, let's send him for a drug test, and then I'm gonna have him talk to a lawyer, and then we'll craft a plan as. It doesn't matter. I'm sending him for a drug test now. To me, what he tells me goes in this ear, goes in that ear. I don't care, right? But the test will tell me what it is. And then at that point, we will also set appropriate conditions. If he's got something more than marijuana, then we're going to take appropriate steps, right? But if it's just marijuana, then, you know, so let's not put the cart ahead of the horse.
Yeah.
For now, let's send it for a drug test.
Yeah.
We'll have him come back and then we'll have a lawyer ready for it. If you can get that to them so that they can reach out to the family, because if I want to know if the family's okay having contact, then what we can do is we can perhaps modify the condition to have him limited contact. Okay? Yeah. So take your time. There's no rush.
I'll call the school and pull the sister. She's in class.
Well, I don't know if that's necessary. Do you have mom? Perhaps we can get mom's phone number from Mr. Martinez. We can reach out that way because I don't want to interrupt her school, you know? Okay.
She's very concerned as well.
Yeah, it's not the end of the world. Everything will work out. Just be nice. It's not hard. And when you get upset, you have to find a different release. Go outside, go
Screw it.
run,
I'm
go
Googling
punch a
it.
tree, find another release. But a person, that's not appropriate.
Go
All
rest,
right?
Kelly.
Okay, come on.
You're not
Thank
gonna
you,
be
Mr. Martinez.
homeless. You'll be
Give me
fine.
your mom's phone number.
832-229-0693.
Say it again.
He travels for work. So is it okay if he goes to Quest if he selected the testing?
Yeah, but you gotta let him know if he doesn't test, then I issue a warrant. But yeah, and it's his responsibility to get the test done and then bring it back to us. Any more ratings? That's it.
I have, I texted Luis for the other Martinez.
Okay.
I Googled it. Nope. All right. For you, Linus, but everybody watching my channel is going to get mad at me.
Is Wade that's on the docket today?
It's from a couple different websites, so I'm pretty sure that's what it is.
Or was that the trial case?
Yeah, that was a trial case.
On violations.
Well, I could have heard it anyways. Today, it came through today, wow.
Guess what he's positive for?
Driving her kids around.
PCP. No?
Alcohol.
Alcohol only? Wow. What kind of case? Yeah.
Kelly, you can come here too.
Yeah. Yeah.
I didn't realize that was a trial case then.
Yeah, that's the ones I emailed you about yesterday.
Yeah, got it.
Judge, while we're waiting on Luis to get here,
Oh, did you cancel the panel?
Yes, I did.
Okay, good.
page 31, Cordova, he's the one you took in yesterday. Do we need a leave the conditions?
Is he out? Is he
Yes,
bonded out?
yes.
Yep. Well, let's wait for the lawyer to get here.
She's not, she said, pick a day, she's out of the country, that's why she was trying to.
I see. Got it. Okay.
So she said, pick a day.
So, Mr. Cordova, come on up. Does she know he bonded out?
Yes, she don't do this.
It was a surety bond, right? They didn't give him a PR bond, right?
It's not posted yet, so I'd imagine it's.
Did you pay to get out or did they give you a PR bond? Okay. The next time you have a violation, your bond will be $15,000 to $20,000. Do you understand?
Yes, sir.
And I'm now modifying your conditions to put a Scram ankle monitor on you so I know that you're not consuming alcohol. Any alcohol whatsoever, and I don't care what it's from. Would you prefer a translator? Are you okay with it?
Understand.
Okay. I don't care what your violation is. I don't care what you're telling me it came from. I don't care if you have high tea with the Queen of England that has alcohol in it. Any positives, you will go back to jail, and I'm going to double or triple your bond. Okay, so he's got to get a Scram ankle monitor today. Waive the fee, and we'll go from there. That's it. No, what does he have now? Okay, so kill the portable, he's gonna have a Scram. Yeah, but wait till the Scram is on him, and then we can take the portable off. Yeah. I will not entertain any excuses. I don't care what
Lori,
you tell me.
Kelly's fine.
You understand?
She's absolutely fine.
Okay, take a seat for me. Rachel will be with you.
Judge, right this way, is discovery complete?
Alex, is discovery complete on Cordova? Please.
Yes.
Were there any offers?
All checks.
That was a quick bonding out.
There's a 15-month probation offer on Cordova.
Okay, thank you.
What about discovery? Is it complete? Luis?
We're missing body worn cam and dash.
Gracias, señor.
Yeah,
Body cam and
body cam and dash. It's only 80 days. Hey, ready?
Luis looks so nice and orange
I'll set it up for trial in court 8, and they're like, can you run over real quick? All right.
Are they going or no?
Yes. Oh, I wouldn't be wearing this if they were. Morning, friends. Linus.
Nope.
You want the cause number, Luis?
Hey,
You already
got it? Okay.
he just hit on you again.
Me
You
llamo
still
Luis.
got
Oh,
his
González.
business.
Martínez, perdón.
Martínez Torres.
Acérquese aquí, por favor, hermanito. Acérquese.
Mr. Martinez Torres.
Pues no me mira a mí, contesta en español. Soy Martínez Torres.
You are charged with
Se le
theft.
acusa con hurto, robo.
You are facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present during questions and interviews with the state of Texas. If you cannot afford a lawyer will be appointed to represent you.
18/2024, officers were flagged down by the complainant at the Home Depot, located at 6810 Gulf Freeway in Harris County, Texas. The complainant observed the defendant concealing tape measures into the purse while her husband
I can't. Every time I pick up a liquor bottle, I drink it.
handed her a few tape measures, which he also concealed into her purse. The defendant walked past all open and operating paying registers without paying. The complainant stated that once the defendant walked outside the store, he approached them and told them they had to go back inside, and the defendant was detained. The complainant stated that once in the office, all merchandise was placed on the desk. The total value taken was $402.20.
Mr. Martinez Torres, I'm going to find that there's probable cause. If you look in the notes, we had set bond at 30,002. Now his bond is set at 5,002. And they've given yet PR bond after PR bond. What happened? I'm not okay with giving you PR bond after PR bond. Your case is extremely old and you continue to take off on us.
I'm sure, Judge, the warrant says 30,000.
Victoria looks so cute today. Look. Michael, you came at the wrong part, Michael. Look at your wife.
No. Do you think that you can just continue to take off and good things happen, Mr. Martinez Torres?
Sí, dejar que las cosas pasen, señor Martínez Torres. No, señor. No, sir. Ayer aparentemente fue bajada a 5,000 $2. Son los mismos, pues, señor. No voltea a mirar. Estoy en la casa.
Does he have any other open cases?
The magistrate did it September 16th, like 2 a.m.
Any other open cases or anything else that we should be aware of?
There's no open cases in Harris County, at least I can run this in history.
That never made sense to me. If you steal something worth X amount of money, it's a felony, or X amount of money, it's not. I think the crime is the crime.
I was in jail. I just got out of jail this morning at 5 a.m.
You shouldn't get another PR bond.
Debería
That's what I'm
recibir
trying to
defensa
tell you.
personal, es lo que estoy tratando de
You
decir.
continue to take off.
Usted continúa con esto siendo
That's not what this was designed to do.
Eso no fue eso no fue diseñado para esto, fue una fianza aseguradora que fue
You
pagada.
posted a surety bond.
Yes.
So one GOB, one PR bond.
GOB, una fianza personal.
I just see 1 or 2 more red flags, Adam. Do you have any felonies? Just tell me you don't have a job or a car and I'm in. Go take a nap, Micah. You work too damn hard.
Let's do this. I'm gonna appoint him a lawyer today and we're gonna figure out what happens with this case today. Take a seat for me in the jury box. Stephen, don't worry about it. Posted a surety bond. Thank you, though. Makes sense. No. I don't care. They can push. There was a reason though. There's gotta, yeah. I mean, they're right though. There's gotta be a reason. Something must have happened. Because I'm not gonna set it that high unless there's some kind of aggravating circumstance, you know?
Yeah, but only towards Fozzie. All right, let's find one more Fleischer before we call it. He's coming.
Okay.
Page 27. The large. Harry, come on up.
All over the letter U.
Good morning, Mrs. Ellers. Sir, you're charged with possession of marijuana. You're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you, and you have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
Yes. Okay. On September 10th, 2024, officers observed the defendant's vehicle with front right headlight not working and failing to turn into first available lane from stop at red light at 6500 block of TC Jester Boulevard in Harris County, Texas. The officer made contact with the defendant, the driver of the vehicle. Officers observed a strong odor of marijuana and had the defendant exit the vehicle. The defendant stated he had marijuana in the vehicle inside center console in a grocery plastic bag. Marijuana was identified based on training experience. The weight was 23.3 grams. The defendant was identified with his Texas ID.
Got it. Okay, Mr. Zellers, I'm going to find that there's probable cause to go forward with the case. Do you have a Texas driver license?
No, sir.
Then you are not allowed to drive.
I had Pennsylvania. I was here down here like I had told. I just came back down here. I had a Pennsylvania driver's license. Like I showed him my car and everything. And he
Hey, hold on. I don't want to talk about the case. My only question is if you have a valid license to drive and liability insurance.
Yes.
Because that's the law.
Yes.
Do you have a valid license? Okay. Can you run his license, please?
Yes, sir.
Well, hang tight. I'm gonna have them run it. Okay. Do you have liability insurance in your name?
Yes, sir.
I want to see it, and if you do, then we'll allow you to drive, Mr. Sellers, okay? So what do you do for a living, sir?
I work at a corner store in Walmart.
Okay, how much money do you make a month?
How much I bring home a month? 2,000, maybe 21.
Okay, are you married?
Yes.
Children?
Yes.
Is your wife, you're currently married?
Yes.
Is your wife what?
She's disabled.
You have the ability to hire a lawyer?
Yes.
Okay, we'll give you time. I'll give you a month. Don't get in any more trouble.
Yes, sir.
That's the only thing I'm asking you to do. I'm not going to put any conditions on you want, just don't get in trouble. If you're driving, you must always have liability insurance so that if you get into an accident, they don't come after you and just take you everything you own. I'm going to have you go to Victoria, sign a reset, and then we'll just get you out of here. And when you come back, please have a lawyer. All right? Okay. No, he has a valid license.
I also believe I think I have a valid license. Woohoo! I couldn't wait to get my license. Just could not wait. And then I got a Mustang right away. Then I went into auto mechanics and started working on cars. I love driving. Always loved driving. And it's just weird because there's 7 billion people on the planet and I happen to be the best driver. Okay. Guys, sorry about the technical difficulties, but they weren't technical at all. They were just me. But we made it through. We made it through. Linus got hit on repeatedly. Linus is going to file a suit against me soon. All right. I will see you guys in a couple hours in Judge Fleischer's courtroom. If I'm late, it's because I'm sleeping, which I have to do at some point in my life. I just have to. But I will be there. I will definitely be there. Thank you so much for coming out, guys. I really, really, really appreciate it. Thanks for hitting the like. I appreciate that too. And I shall see you guys in a couple hours. Behave, okay? Bye.
Got these lights that goes digital dreams. Through the screen, her blue eyes gleam. Wicked humor, sharp as a knife. Her stream sparks electric light. Late at night when the world sleeps, she's the friend that always keeps. Giggles roll like thunder loud. She stands out in any crowd. Cassie's laugh cuts through the gloom. Eyes blue like a summer's bloom. Her humor dark and twisted sharp. In a way, there's no alarm. Freedom tales waiting to the night. Her laughter feels just right. Even when my world turns gray, with a giggle, she lights the way. Her eyes near a sky so blue. In her jokes, there's a truth so true. With each string, she brings the light. Turns dark days into bright. Kathy's laugh cuts through the gloom. Eyes blue like a summer's moon. Her humor dark and twisted sharp. In a way, there's no alarm. Streaming tales late into the night. Her laughter feels just right. Even when my world turns gray, with a giggle, she lights the way. Kathy's laugh cuts through the gloom. Eyes blue like a summer's bloom. Her humor dark and twisted sharp. In a way, there's no alarm.